On today's LawNext, when it comes to contract negotiations, lawyers often find themselves spending countless hours haggling over standard agreements, such as NDAs and SaaS contracts, with both sides often saying more or less the same thing, but in different words. What if there was a better way? Today I'm joined by Electra Japonas, whose company, OneNDA, was recently acquired by Law Insider. And we're also joined later in the show by Law Insider's president, Preston Clark. Together, they are on a mission to revolutionize contract negotiations by developing and open sourcing a suite of standard agreements. They started with OneNDA, which has been adopted by over 6,000 organizations, and they've just launched their OneSaaS standard. And now they're setting their sights on developing an entire library of standard agreements. Today, we're going to explore how they're building these standards through community input, AI analysis, and careful consideration of diverse business needs. We'll also discuss their vision for the future of contracting and how technology will play a crucial role in transforming the way legal teams handle routine agreements. I'm Bob Ambrogi, and this is LawNext, the podcast that features the innovators and entrepreneurs who are driving what's next in law. Before we get to today's conversation, please take a moment to hear from the sponsors who so generously support this podcast. Whether you specialize in workers' compensation, employment and labor, or insurance defense, Case is tailor-made to your law firm's needs. Stop struggling with generic software that forces you to adapt. With intelligent email and document management, precise time tracking, online payment reconciliation, and more, Case streamlines your entire practice. Join the firms that have discovered what practice management should be at meruscase.com. That's MERUSCASE.com. Now let's get to today's conversation. Electra, welcome to LawNext.
Thank you for having me. It's great to be here.
So you've had a busy few months, I would say. Back in October, your company, OneNDA, was acquired by Law Insider, and I know you were doing a lot around OneNDA standards before that, and you've pretty much probably accelerated what you've been doing in that area since then. So hopefully today we can talk a little bit about both your work, but what this means for the industry more broadly. So why don't we kind of start with you telling us a little bit about who you are and what you do and how you got to where you are right now?
Yeah, sure. So I'm Electra. I was an in-house lawyer, or had worked within organizations in a quasi-legal role, often sitting on the delivery side of things. So I used to work in organizations where I was in big IT projects. And although I had a legal and contracts background and responsibility, a lot of the stuff I did was operationalize really large IT contracts to make sure that the suppliers were held to account, internal stakeholders understood their rights and obligations. So I didn't ever have a very traditional legal upbringing, if you like. And so having spent 10 years in these large organizations, I decided to start a business, which was called TLB. And that was a legal operations consultancy. And during my time at TLB, I saw that there was just enormous redundancy when it came to routine contracts. So during the height of the pandemic, TLB grew exponentially because one of our offerings was outsourced contract review for in-house lawyers. And our business just quadrupled during that time. And so at the end of the year, we did a deep dive to figure out how many contracts we'd reviewed, what types of agreements we were looking at. And we found out that 63% of all agreements we'd reviewed were NDAs. And of course, this is insane because the whole purpose of TLB was to streamline the way in-house lawyers worked. And I'd seen firsthand in these large organizations where I was that in-house lawyers weren't really able to feel like they were fully delivering the value that they wanted. They wanted to get more involved with the business. The business wanted more out of them, but somehow there was just a mismatch. And that's really the bridge that I wanted to cover with TLB. So the whole premise of the business was to streamline the way in-house legal worked. And it felt like we were part of the problem rather than a solution. And so I took to LinkedIn and I put a thought out there. And that thought was, why don't we just agree to a standard non-disclosure agreement form that we all agree to adopt as our own, so that next time you enter into negotiation with a third party, you're starting from the same starting point. You have a common framework. And that post went viral. I had loads of messages from loads of lawyers saying, please do this. I thought about this 10 years ago. Why hasn't anyone done it yet? I started the OneNDA initiative. And then 3 years down the line, it's been adopted by almost 6,000 organizations. And we estimate it gets signed around 10 million times a year. So the numbers are huge. The impact is huge. And so with the acquisition of Law Insider last October, it's an opportunity and a platform for us to scale this beyond just the NDA and beyond just the thousands into the hundreds of thousands and millions. We have big ambitions for where OneNDA and the other standards that we're building are going.
So explain what that is. What is the OneNDA initiative and what is this kind of idea about standards in contracting?
Yeah, so my first job was at the European Space Agency. And during my time there, the European Space Agency is an organization that is publicly funded by countries who want to be part of the space program. And the European Space Agency is there to facilitate business between each jurisdiction that's putting money into this fund and to give them contracts back so that they can get the value of the money that they've put into the fund. And one of their initiatives, of course, was to create a standard contract form. And so if you look at the European space industry, they all contract on the same form. And they don't all have identical forms, but they all have the same starting point. So I was kind of raised, my legal career was entrenched with this idea of standardization. And of course, when you're working with space engineers, they don't want to spend time on unnecessary contract negotiation or battle of the forms or anything like that. So it's a very logical way of contracting. And I always thought, this is slick. It was, of course, sometimes awkward when I had to defend a contract that I didn't fully agree with, but I saw the benefits. And so I would be very open with someone who, when there was a contentious area that I may not have agreed with, I was very open that, look, this is how we do business and this is a starting point and we can iterate. But the fact that we're both on one form is a very efficient way of contracting. And then I went into industry. Then I went into more commercial organizations like Disney or EY or British American Tobacco. And every organization had their own terms, their own template that was skewed in their favor. And so every time a negotiation begun, one party sends their contract to the other party has to review it, retrofit the contract back to their own preferences. That process took a long time. Then, of course, you start with the red line ping pong. It damages relationships. It delays deals. It takes lawyers away from the more strategic work. It's pointless because at the end of the day, most clauses, particularly boilerplate provisions, say the same thing, but in different words. So why on earth are we in this day and age negotiating contracts that say the same thing, but expressed differently so that we can preserve pride of authorship or fear that if we don't shoehorn every single possible risk that we can fathom into our terms, that we're exposing our organization to undue risk. And so it's not pragmatic because you start here and the other side starts here. And then, of course, you inch your way back into the middle. It's a very expensive and laborious process that can be relationship destroying in some instances. And so the premise of let's all just agree to one standard template that is balanced and neutral and a market standard was something that I thought would be a very good solution to this enormous redundancy that we were seeing when it came to routine contracts. And the NDA is the lowest hanging fruit. Everyone hates them. No one really sees the value. They very rarely get litigated. And so I thought it was a great starting point for us to start a movement for global contract standardization.
I want to say that you learned at the space agency that this is not rocket science.
Yes,
is that
absolutely.
Fair to say?
Yes, that's so good.
But That said, doesn't it kind of go contrary to the way a lot of lawyers think about this? I mean, I think lawyers think that every agreement they negotiate is somehow that special snowflake that has to have their language or their negotiated language. I mean, how do you get lawyers to buy into this concept? How hard is that? How much of a challenge is that?
I mean, it is a challenge. However, there is appetite. So the challenge comes when there is a lawyer who believes that their way of contracting or the nature of their business is so bespoke that it requires bespoke language. Very few agreements require overly bespoke language for the majority of the contract. Most of the contract is boilerplate. We see the same clauses again and again and again, and we negotiate the same stuff again and again and again. And we're also doing two things with our brain when we're negotiating. First, we're assessing whether we think this type of provision should be in the agreement and the premise of the provision is correct. And then we're also tinkering with the language. Oh, let's put this word here and this comma here. And often that's important, but I'd say that in 99% of the instances, it's not. So we're almost working in the realm of contracts for the edge cases, right? And lawyers have often been rewarded for doing this and having that level of accuracy and striving for perfection in everything we do has been something that we have been rewarded for a very long time. But it's not conducive to speeding up business deals. And I'm not suggesting that lawyers adopt a form that's not fit for purpose, but I am suggesting that we take a more pragmatic view of our risk appetite and how that translates in reality. Because if you're going to die on a hill over an NDA provision that is, the definition of confidential information, which in most instances is exactly the same, then you're giving up speed for covering a potential risk that is extremely unlikely to materialize. So it's a cost-benefit analysis. Is your perfect contract, because, by the way, perfection does not exist, but is your perfect contract worth the additional time it takes to go to market or to get a deal done or to get that cash flow going? So it is a cost-benefits analysis that lawyers, I think, need to be pragmatic about. And they are, because we do have 6,000 adopters and we've had hundreds of lawyers that were involved in OneSaaS, which is our latest initiative. And they've done that with much gusto and enthusiasm. And there is a lot of appetite for us to stop working in ways that aren't conducive to speed.
Have you ever estimated what this means to, say, legal departments in terms of that cost-benefit analysis? What kinds of impact can that have on the costs of negotiating NDAs or whatever other standard agreement might be?
I mean, we don't actually have any data around this that is reliable because we're not very good at collating that level of data. However, I know from first-hand experience when I worked in-house that an NDA can take weeks to negotiate, and larger agreements can take up to a year to negotiate. So you're spending all this time going back and forth over points that the business is rolling their eyes at in many instances because they're saying, that's not a pragmatic risk, or I don't think you fully understood the nature of what we're doing. And I'm not saying this is the case in all instances. However, it happens. And so I think that taking a standardized approach to the types of agreements that we're looking at, which are more routine and lower risk, is a really sensible way forward that will undoubtedly have a major impact. And because OneNDA has been so widely adopted, I had an email the other day from someone that said the time that it takes us to get to an NDA signature has more than halved just by adopting OneNDA. So we've got people that are saying this. I'd love to have more data to show, and I'm going to try and do that over the next year when we're able to offer more technology as well that will facilitate the way that people use OneNDA. And so that will give us the data that we need to report back on that.
As this episode is airing, you are in Miami at the first conference that you're having at the University of Miami. Future Contracts, is that what it was called? I believe?
That's right. Yeah.
Future Contracts. Okay. And you've just announced this OneSaaS standard that you mentioned. Well, let's start there. Why don't you tell us about OneSaaS, and then I have some other questions about it. But what is that?
Yeah, so OneSaaS is the next agreement. So we standardized the non-disclosure agreement, and straight after that, we standardized a non-disclosure agreement that was specific to M&A transactions. So it's called OneNDA plus M&A. And then after that, we did OneDPA, which is a data processing agreement, which was standardized. And then we had a break for a while we figured everything out. And then after the acquisition by Law Insider, the very next initiative was OneSaaS. And OneSaaS is a cloud services agreement that has been standardized. The methodology that we followed was very close to what we did with OneNDA, but with enhancements, because hindsight is wonderful, as is AI, as is the data that the Law Insider public library provides us with. So I'll talk about the methodology in a moment. But OneSaaS is a standard cloud services agreement that will save SaaS vendors and SaaS buyers a lot of time and money. And that's because SaaS agreements are predominantly the same. A lot of the stuff that's in there is so similar, and I have data to prove that, actually. So I'll talk about that in a minute when we go through the methodology.
Yeah, well, I want to talk about the methodology because, I think there are probably some people listening to this saying, okay, that kind of makes sense, but who is Electra to decree what the standard should be for an NDA or for a SaaS agreement? So you don't decree this, right? I mean, how do you go about developing what this standard should look like?
Yeah, so the methodology is an integral part of all our initiatives, and we make sure that we get as much buy-in from as many people at the outset. And I think that's key to adoption as well, because there have been attempts previously to decree a standard and say, now this is a market standard, everyone just use this. But it doesn't work that way, because you need to get people to buy into the standard and the process and the vision from the beginning. So the way we approached OneSaaS, and this is, as I said, with the learnings that we had from OneNDA, is that the first thing we did is we asked people to tell us what they'd like to see next. What contract should we standardize next? And SaaS was overwhelmingly the favorite. And the reasons for that.
When you say you ask people, who are the people you're asking? Who do you?
Yeah, so good question. We have a large community of OneNDA enthusiasts, OneNDA adopters, people that signed up to our newsletter, people that we met at different events. So we reached out to the legal community and we asked them what they'd like to see next. And we did this democratically by vote. So the SaaS agreement was the number one popular agreement that was voted for, and that's what we did. So we were led by this community when we chose this agreement. And then the way we approached it was to take a sample of around 1,000 agreements from the Law Insider public library of SaaS agreements. And then we used AI to analyze these agreements. And what we found was that in these 1,000 SaaS agreements, there were 819 different clause titles. However, when we boiled those down, again, with the use of AI, when we boiled those down to substance, there were only 52 different clauses, substantially different clauses. So these 52 clauses are just getting reused and reused and reused and renamed and expressed differently. But ultimately, across 1,000 agreements, there were only 52 substantially different clauses. And that was our starting point. Now, as an aside, what I will say is that often when you're reviewing contracts day in, day out, it does feel like Groundhog Day because you're reviewing the same stuff that you review every day. It's not a riveting exercise because you've read a warranty clause before, you've read an indemnity clause before, you've read a liability clause. You know that an NDA shouldn't include this language, but because you can't be sure that it's there, because of this variation that I just described, you've got to be extra vigilant when you're reviewing it manually. But of course, you've seen it all before. So it's a very stressful experience reviewing a contract, right? It's not, it's kind of boring and stressful at the same time because you're not sure, but you've seen it all before. And I think this data proves and shows why that's the case. So we took these 52 functions, as we called them, and they were basically statements that abstracted complexity from the notion of a clause. So if you take a clause is a bunch of words that expresses a function, right? And so what we wanted to do is make sure that when we pull together this community to decide what should be in the OneSaaS agreement, they weren't bogged down by that detail of, oh, do I like this language that's expressing this function? Because now I'm going to do two things. I'm going to assess the function, but I'm also going to assess the language that expresses it. So we abstracted complexity by just setting out the functions, and we got the steering committee, which was a subset of the people that had signed up willingly to take part in the creation of OneSaaS. And we tried to make that group as diverse as possible. So we wanted to have lots of tech vendors, but also lots of tech buyers. We wanted to have people from large organizations, small organizations. We wanted an international presence. So we tried to make that group as diverse as possible. And together, we co-created OneSaaS. So the process was they voted on the functions that they thought should be in or out. And then from those that were in, whether those needed to be baseline, so i.e. non-negotiable, or variable. So they would be changeable. And after we had that framework, we then again used AI and Law Insider's library to pull the most commonly used wording to express those functions. And from there, we drafted the first version of OneSaaS. I then published that to the broader OneSaaS community. They tore it apart, of course. Everyone was commenting. I had over 550 comments. We incorporated those comments into the agreement where there was consensus that that should be the case. And then from there, we reissued version 1. And then again, we had a final round of comments. And the question that we asked there was, is there anything in here that would stop you from adopting OneSaaS? Because that's really what we want to know. What are the blockers to adoption? So we collated that information or that feedback. We incorporated it back into OneSaaS again. And now today, we're releasing the first official version of OneSaaS ready for adoption.
How do you account for, or do you need to account for distinctions among jurisdictions or industries, that sort of thing?
Yeah, we try as much as possible. So this is why we need a diverse group of people, and we need this to be widely reviewed and stress tested before we release the first version. So we've had comments like, this wouldn't work in Germany because we need the signature to be below the terms. Or someone else, would say, in our industry, which is regulated, we need to have these types of provisions in there, otherwise we won't be able to adopt it. We're not trying to please every single person in every single jurisdiction. We understand that that's not a reasonable expectation from the first version of OneSaaS, but we try to cast the net as wide as possible. And then what we'll do, and this is what we've done with OneNDA, we'll keep the feedback round open perpetually. So we want people to give us their feedback of OneSaaS after they've used it. And then if we need to build additional modules that people can include into OneSaaS to make it fit for purpose for an additional use case or for a separate jurisdiction, then we can do that. But we want to do it iteratively, like any good product would.
Yeah. How does this actually work in practical terms? If I'm an in-house lawyer at X corporation and I want to use this SaaS agreement, what does it cost me? How do I do it?
It's completely free, and it has to be. Otherwise, we won't get the network effect and we won't achieve the objective of let's streamline negotiations and stop the time that it takes us to process these types of agreements. So it's completely free, and it always will be. So this is an open source document. It's there to be adopted. And the way you adopt it is by filling in a form to tell us that you've adopted it. Adoption, just to clarify, means that you agree that you're going to use this as your organizational template, as your default contract when you send out your agreement, or that you agree that if someone else sends you this, you will accept it with minimal to no negotiation. So adoption is effectively a declaration that you're committed to this cause. And it also shows that you're a forward-thinking organization that isn't trying to negotiate over words and details that are slowing down deals. And I think lots of organizations really want their names to be on the directory. I was surprised at how passionate people were about getting their names on the directory. And I think it's because it positions them as that innovative legal team that is much more interested in building relationships than protecting every single risk or guarding against every single risk that they can perceive.
Yeah. You've got one NDA, you've got one DPA, one SaaS. How far can standardization go? What other types of agreements are ripe for standardization?
That's a good question, and one that I have been thinking about a lot. And I think that this is exactly where the community comes in and where they will lead us. So we've already asked the community what they think we should build next after OneSaaS. Sneak peek is that OneMSA is right at the top at the moment. So Master Services Agreement looks like could be the likely next candidate. But we want to continue to build not just standards, but also variations of existing standards to broaden their use case and make it more fit for purpose for a broader audience. So we will continue to standardize. And at some point, people may be able to just use standard clauses to build their own contracts. This is a vision that I've had from the outset around how we can have modular contracts that are used in a very versatile way.
Yeah. And I assume you would say that there are, maybe you wouldn't say this, there must be some agreements that are not susceptible to being standardized. Is that fair to say?
For sure. I think that there are some agreements that are so bespoke in nature and cover such a niche use case that there is, firstly, no point in standardizing. And secondly, you need someone who's going to craft that to meticulously reflect the agreement between the parties. And there is maybe even a template for that. But I would say that even in that agreement, you might still have a liability cap or a warranty or a definition of confidential information, in which case you can bring in some standardized either clauses or templates to help you with that.
Coming up in the second part of today's conversation, we're going to be joined by a second guest, Preston Clark, the founder and CEO of Law Insider, the company that acquired OneNDA last year. We'll continue our conversation about how technology and standardization could reshape the future of contracting and contract automation. But first, take this opportunity to learn about the sponsors who so generously support this podcast. What if your legal software really understood your specialty? For workers' compensation, employment and labor, and insurance defense firms, Case is that solution. Case has every feature built around how you actually practice law, from automated document workflows to native billing and payment reconciliation. Experience the difference tailor-made software can make for your practice. Visit MerisCase.com today to find out why specialized firms choose Case. That's MERUSCASE.com. Welcome back to LawNext, where I've been speaking so far with Electra Japonas, the founder of OneNDA, which was acquired in October 2024 by Law Insider, a company that provides what it says is the world's largest public contracts database. As we return to the show, we are joined by Preston Clark, the founder and CEO of Law Insider, who shares his perspectives on contract standardization and what it could mean for the legal industry. Let's get back to that conversation. Listeners, Preston was supposed to be here at the outset of this recording, but unfortunately his business took him away. So I invited him to stop in whenever he could. So how you doing?
Oh, I'm great. Yeah, business is good. And that means that we're in the process of bringing on a large public company and lots of hoops to jump through. So I apologize for not being here, but I am doing great, Bob. Thank you.
No problem. Real quick, why don't you say who you are and what do you do?
Sure. I am Preston Clark, former in-house attorney, but have spent 15 years plus building software companies. I'm the co-founder and president of Law Insider, which is the company that acquired OneNDA and that is honored to employ Electra as our chief legal officer. And I'm a serial entrepreneur. So I also own and co-founded a company called SimpleDocs, which is in the AI contract automation space. And I love contracts. So that's me.
Preston, we've been talking about one NDA, about OneSaaS, the announcement today, as this is airing, of OneSaaS. Um, what are your thoughts on this idea of standardization and why it matters in the legal industry?
Yeah. So I think I agree with everything Electra would have said and everything she's written about in the past
She's
from
been
an
brilliant, yeah.
ideology perspective. Waste of time. We're reviewing the same clauses written differently. It's inefficient. It's not why we went to law school. It's slowing down business. Like all of these things inherently or sort of instinctually make sense to me. The business side, though, sort of the capitalist in me, which is very strong, is saying, gosh, when lawyers use Law Insider today, or when they use ChatGPT, they don't really tell anyone about it. And it's not because it's inappropriate to use those tools. It's because we're not celebrating the sources of our work product. And nor do I think we should. If you're using Canva for designing something, you're not like, oh, I built this in Canva to your client. You're like, here's the work product. For a company like Law Insider that is trying to scale and trying to build a really big global brand, that ends up hurting us because it means that people aren't telling each other about the tool. And in some cases, it might even be viewed as a secret. And I think what a standard represents, and this is reflective of Electra's LinkedIn persona, the community that she's built around OneNDA and soon around OneSaaS, is that this is something that is celebrated. And that creates network effects. And now suddenly, instead of as lawyers drafting an agreement from scratch or sort of representing it's from scratch, and sort of saying, this is my work product, we're now saying, no, I don't want to draft this from scratch because I don't want the counterparty to push back as much. I want it to be balanced. I want it to be mutual. I want it to be following best practices. And so I adopt OneNDA or I adopt OneSaaS. And for Law Insider to capture the halo effect of that and for people to say, I am an adopter of the Law Insider standards, that's a really big deal for us as a brand and as a business. And even though the standards themselves are free, there's lots of offshoots commercially that can be monetized in the future. And so I just, I think that part is really important to me because Rocket Lawyer for, Charlie Moore for 15 years or 20 years has been pushing out a builder with free templates. But even then, you're not celebrating Rocket Lawyer. You're not celebrating your contracts attorney who drafted it. And so to get that benefit where if one NDA is signed 10 million times a year and every one of those has a badge on top that says powered by Law Insider standards, that is a network effect that is incredibly valuable, incredibly powerful to us, as well as to the community that's using it.
Yeah. Electra, you've described, I think you said more than 6,000 users for one NDA. But I assume you've also encountered doubters, skeptics, people who question this whole concept. What have you found to be effective in addressing concerns that some legal professionals may have about using standardized agreements such as these?
I mean, I think that you don't need to address all of it. If someone's really skeptical and really doubting the power of standardization or the benefits that they can get, we don't need to proselytize them. We don't need to persuade them to adopt a standard. The power of persuasion comes from the network effect that Preston just described. Because if that person who's doubting it keeps getting one NDA from its counterparts, then that's really what's needed to push them to realize that this is a change in the way that we contract and that people are prioritizing speed and agility and balance and fairness over having my terms exactly as I want them every single time. So, yeah, we don't really try and address those concerns because I think that the whole messaging behind why standards are a good idea is just embedded in everything that we do and say. And so those messages are out there for those people to consume. And if they don't agree, that's completely okay.
Electra and I talk a lot about fights that we need to win and want to win and fights that we just don't. And we all exist in the LinkedIn echo chamber. And I think we end up feeling like there's fights that we need to win. And one example is, is the document good? Is it drafted the right way? And there's plenty of academics of whom I will not name, but we know who they are, who have taken shots at OneNDA, and Electra and I talk like, it's just okay. We don't need, like, they're entitled to that opinion. They may in fact be right, and that's okay. Another version of it is this isn't the only standard. It's not only OneNDA is not only the only NDA standard, but there's other cloud service agreements. And so people will say, well, how is this compared to bond terms or something else? And it's like, hey, we love Todd. Todd's a great guy. He is a great standard. You're going to need to answer that for yourselves. We'll tell you mechanically how it's different, but qualitatively, you're going to need to make that assessment, and it's going to be the network effects that decide ultimately. Because if it's sort of like, was Betamax better than VHS? Doesn't matter. In the end, the one that has the most VCRs out there in the world is the one that wins. And so, I'd like to think qualitatively, Electra's putting out exceptional work with the steering committee. But sort of our taste, or the market's taste, or an expert's taste, ends up mattering less when those network effects come into play.
So does that suggest that you believe there will be one standard that will eventually emerge as the dominant standard?
I think there has to be. Yeah.
Yeah, I do. I think so, because I think that the leverage that lawyers get from adopting a standard is in the volume of that standard's adoption. So if everyone's buying into one standard, then I think that will by default give people more benefits, and they will veer towards that.
Yeah. A couple of things I want to talk about. One is, okay, so as of the airing today, you've released the latest standard, the SaaS standard. Where do you go from here? What's next on the radar, the roadmap, in terms of building this out?
Yeah, so I'll be very honest and very transparent about this. We're going to publish more standards, and each of these takes a ton of work, as Electra will tell you. But we have an ambition to have a Law Insider Standards hub that will have dozens of standards, and within those standards, there'll be variations and versions that might be industry specific, that might have different languages, different formats. And the ultimate goal is to have a library of these standards, and so that if someone hears about OneNDA and they come in, that they will in time, adopt other standards as well. So that's sort of one part of it. And then our North Star, sort of our OKRs or our KPIs, is in download. How many standards are being downloaded every day, every week, every month? Law Insider has millions of contract downloads every month, or every year, excuse me. What percentage of the people who come in to find a general sample will stay for a standard? So that's sort of goal number one, is, can we have huge numbers? Can we get to 1 million standard downloads a year, just as an immediate North Star? And I think that we can. And I think in order to achieve that, though, we need more than just OneNDA or more than just OneSaaS. But secondarily, the vision ultimately is to turn these into not Word document downloads, Bob, but to turn it into a builder experience where you can come in, whether you're a big company or a small company or an in-house team or a founder, input the fields that are dynamic and unique to your business, jurisdiction, confidentiality, period, address, whatever. And phase one, download an agreement that is pre-populated and ready to be sent. But phase two, which will be April or May, complete the process and actually send it out for counterparty review and signing, with the idea being that if we're having 1 million people a year download a standard, instead of 1 million people downloading and taking a Word document with them, there's going to be 1 million people or 1 million events where an NDA or a cloud service agreement is being generated and sent out. And over time, our hope is that both small, mid-size, and even large companies will use Law Insider as a hub or as a central platform for generating and automating its most routine, highest volume agreements. And so while we're establishing this brand as a standard, as a peer-reviewed, steer committee developed standard document, the workflow automation that underpins it, that enables you to process this at a much faster rate than you would have before, becomes sort of core to our service offering. So it looks, to put it bluntly, it is a free version of Rocket Lawyer. It's a free version of eforms.com. It is we're going after the template companies, the builder companies, but offering it for free, but focusing not on wills and termination letters, but focused on in-house use cases, business contracts, commercial contracts. And then the last piece is then layering that with AI, because for every contract standard, there's a corresponding playbook, which is a set of rules that govern that agreement. NDAs don't include non-solicitation, and one NDA doesn't, and so it should be omitted. And so if I get a third-party NDA that comes in, there should be an AI tool that reviews that NDA and automatically redlines out non-solicitation. So the on my whiteboard over here, it has standards at the top, and then standard downloads is the goal. And then from the downloads, it's builder, it's AI capabilities, and monetization comes when we're able to get enough.
I was wondering when you're going to get to the monetization part.
Yeah. So all of this is just power usage driven, right? Which is Law Insider to the core, right? Like for 7 years, Law Insider was just totally free. And then now there's a paywall, but only a fraction of the users ever see the paywall. It's like Duolingo. Most people don't pay for Duolingo, but the 1% that do make it a publicly traded, very successful company. And so for us, the idea is that getting people into these tools, getting them automating, not only saying I want to adopt a standard, but I want to automate a standard, and I want a corresponding playbook to redline when I can't use my standard because someone else is insisting on their version. That ecosystem, enabling it with free tools and then monetizing on the power usage side, I think will create an incredibly powerful flywheel, because every time these NDAs go out or SaaS agreements go out, it's going to introduce a new person into our community who said, gosh, what's one NDA? I've never heard of it before. Let me take a look. So that is the business thesis. But in the process, it means that we're giving a ton of value for free. We're delivering a lot of software for free, in addition to just the quality of the standard document itself. And I think that will represent a lot of sort of permanent brand equity for us, while also producing a really profitable business at the same time.
Yeah. And you mentioned earlier that you also have this company, Simple Docs, and is Simple Docs the technology that's driving that sort of assembly process that you're talking about? Yeah,
it is. So you will see this play out a little bit in I guess today, February 10th, but also, in the weeks to come. But Law Insider and Simple Docs are going to be announcing a technology integration partnership whereby Simple Docs is powering user experiences that are native to the Law Insider user. So you're not sort of jumping off into Simple Docs, but this is all the mechanics that I just described, the builder experience, the send, the e-sign integrations, the AI powered review, integrations into Electra's playbooks. These are core functionality that Simple Docs has already built. And so the next step in bringing these brands together is to create sort of the corresponding native version within Law Insider. Simple Docs very much serves the top of the market, publicly traded companies, global multinational, like large multinationals, and Law Insider is sort of serves the world. And so the idea is that by enabling Law Insider to have these tools, that we're able to reach a market and build a brand that is just much broader in nature than anything that Simple Docs would have or even would intend to do on its own.
Yeah, Electra, anything else that you want to say to kind of expand on that or add to what Preston says in terms of the vision and the future here?
I think that it's a very complementary what each organization is doing. And I also think, just as an ideological person who has grappled with contracts in my profession and in my day-to-day, I think that this combination is the only way that we're actually going to solve the contracts problem. So beyond, the business case and the reason for Preston wanting to do this and for us all to want to be involved, contracts are a big problem, and it's been really difficult to solve with just one thing, like just technology or just even a template or just a different process. I think this combination of data, technology, and community plus standardization and this notion that we can work better if we're more collaborative is a combination that we haven't seen before in the market. And I really believe that this is the only way that we're going to solve the contracts problem that we have. And I'm really excited as to what's going to happen over the next few months.
Sounds really exciting. One last question, only because I know that as this is airing, you are both at this Future Contracts Miami conference going on. Real quick, what's it about? What are you doing there?
It's all about contracts. I think that we wanted to do a conference at the University of Miami. It's where I went to law school. We're big donors to the transactional skills department and big believers in transactional skills education as sort of a practical application of an educational model that law school generally is not that practical. I hope that's not a controversial take. And what Marcia Weldon is doing there is incredible. And so we're very supportive. But this conference being hosted centrally around the topic of future contracts means that we're going to talk about AI. We're going to talk to law students about what they're learning and how they're preparing themselves differently for the future. We're going to have big law partners from Denton's, from Holland and Knight talking about how they are incorporating AI and other automations into their practice. We're going to have tech companies like Google and PayPal there talking about what they're doing. So it is, there's lots of legal tech conferences, maybe too many. And we wanted to do one that just went really, really deep in how contracts are evolving. And we have a great lineup, and I think we're up to 300 registered attendees. So for a first conference, as anyone will tell you, pulling off a first conference is really hard. But we're really happy with how it's coming together.
That's great. Well, it's really interesting what you're working on, and Electra, I appreciate your time and talking about it. And Preston, your cameo appearance on the show, your walk on here,
thanks,
is
Bob.
Appreciated as well. Good to see you both, and thanks for your time today.
Thank you.
Thanks for tuning in to today's show. I hope you enjoyed it. If you'd like to share your own thoughts or comments, you can do it by messaging me on LinkedIn or other social media, or just email me directly. It's ambrogi@gmail.com. If you're a fan of LawNext, please leave us a review wherever you get your podcasts. LawNext is a production of LawNext Media. I'm your host, Bob Ambrogi. Hope you'll join us next time for another episode of LawNext.